The FCRA Amendment Bill 2026, in my view, is a draconian legislation. It is another official loot of properties and assets, primarily of minorities, charitable institutions, NGOs, news channels and other bodies who do not toe the line of the government. First, do you remember the Goa government brought the Goa Escheat Forfeiture and Bona Vacancia Bill in 2024, that is to take away properties where there are no heirs or what they call abandoned properties. And I opposed this on the floor of the House when it was introduced and was being passed, and I called it an official land grab. At that time nothing was said, but 1 year later, because I had shot one video and sent it to Australia and it started becoming viral, I think the BJP did not like it and the government did not like, especially the use of the words official land grab, and calling attention was moved with an intention that I should withdraw this video, and probably they expected I would tender some apology. And when I repeated the words and I maintained my ground, the Chief Minister Dr. Sawant got very offended and tried to shout me down and demand that I should withdraw the video and my words, and I refused and I stood my ground and the government could do nothing about it. This FCRA Bill 2026 is similarly draconian and also another land grab which I will explain to you, and a new method by which the government wants to grab properties and even jail people. Firstly, section 14 is sought to be amended by adding section 14b, and I will read that provision, section 14b. Number 1, the certificate shall be deemed to have ceased on the expiry of its period of validity if a. the application for renewal has not been made under subsection 2 of section 16, b. the application for renewal has been made but refused by the central government under second proviso to subsection 3 of section 16, or c. the certificate is not renewed before its expiry. Subsection 2 says this: no person whose certificate has ceased to exist shall either receive or utilize the foreign contribution unless a certificate is renewed. Now what does this mean? Clause A is a certificate ceases when not applied for renewal. This is the fault of the license holder or the certificate holder. Now clause B, the certificate ceases when refused. That means if your certificate renewal is refused, you are out. Clause C now, certificate is not renewed before its expiry. What does this mean? The renewal is not in your hands. You apply for renewal in time, but the renewal is in the hands of the central government. So if the central government does not decide your application before the date of the expiry and the renewal does not take place and keeps it pending, you get stuck and this clause kicks in. So now see subsection 2 which I just read. I will read it again. No person whose certificate has ceased to exist, now it has ceased to exist, shall either receive or utilize the foreign contribution unless the certificate is renewed. The consequence is this: the result in all these cases is provided in subsection 2, which prohibits a person whose certificate has ceased to exist to receive or utilize foreign contribution received, means you are frozen. Also chapter 3A has been introduced in this 2026 bill, and the relevant provisions are these. I am going to read that. Chapter 3A, vesting of foreign contribution and assets in designated authority. That means that foreign contribution which has come will go to the government of India, and also the assets will go to them. Now see how the provision is. 16A, 1. The foreign contribution and assets created out of foreign contribution of any person, A, whose certificate has been cancelled under section 14, or B, who has surrendered the certificate under section 14A, or C, whose certificate has ceased, that is the word ceased, under section 14B, or any rules made under this act, shall from the date of such cancellation, surrender or cessation vest provisionally in the designated authority in such manner as may be prescribed. Now look at this subsection 2. An asset shall vest wholly in the designated authority whether created or acquired partly from foreign contribution and partly from other sources, provided the person referred to in subsection 1 may make an application to a designated authority for return of any distinct or ascertainable portion of the asset created or acquired from other sources, and the designated authority, on being satisfied, shall on order return such portion of the asset to the applicant in such manner as may be prescribed. Then we have 16b. The provisions of the Act as amended by the Foreign Contribution Regulation Amendment Act 2026 shall apply to all foreign contributions and assets created out of foreign contributions vested under section 15 as omitted by the said Act, or any rules made under this Act as it stood immediately before the commencement of the said Amendment Act, and all such foreign contributions and assets shall, from the date of commencement of the Foreign Contribution Regulation Amendment Act 2026, shall be deemed to be provisionally vested in the designated authority under subsection 1 of section 16a. And now look at this, section 16(6)(c). Notwithstanding anything containing any other law for the time being in force, where any person who was permitted to accept foreign contribution under this Act ceases to exist or is rendered inoperative or defunct, a. the last key functionary of such person shall inform the central government of such cessation or status of being inoperative or defunct in such form and manner within such period as may be prescribed. B. The foreign contribution received by such persons and the assets created out of the foreign contribution shall stand permanently vested in the designated authority under subsection 5 of section 16a. Now, by introducing chapter 3a, it is giving powers to vest the property when the certificate has been cancelled or surrendered, or when the certificate has ceased. I pointed out section 14b, how it ceases. If it is not renewed, it ceases, and the vesting of the property goes directly in the designated authority. So, which means, now look at this other parts which I read. Even after you wind up, you cannot sell that asset, but the foreign contribution received by such person and the assets created out of the foreign contribution shall stand permanently vested in designated authority. So, if you brought in foreign capital under the FCRA route and you do not desire to continue any foreign contributions, and therefore, you do not want to continue with the registration, and you surrender the certificate and you end up getting stuck and losing your property. Now think, I brought in foreign contributions to build a hospital. I build a hospital, fully utilize the money, and tomorrow I do not want any more foreign contribution. I am happy because I feel I have got good funds, some good philanthropist, some charitable institution, some company, somebody is sponsoring me. So, I do not want any foreign exchange, I do not want foreign contribution. So, I ask for cancellation, so I surrender. What does this law say? You surrender and that property only goes. Even this property was brought before this law came into force. This law will apply even retrospectively, please understand this. So, you are surrendering, you have utilized it fully for the purpose why you brought it, you are not in fault, you are not in default, and still by this amendment you are going to be stripped naked, completely taken off all your clothes, and you will be like the king who always thought that he had clothes when he had nothing. And this is how you will remain, the bodies will remain with nothing in their hand when once they themselves surrender registration, the certificate, or all these things happen, how the certificate is not renewed in time. Now, even 16a2, as I said, it is why it is more draconian. Then asset shall vest in the designator whether created or acquired partly from foreign contribution and partly from other sources. Now, you see this, tomorrow let us put theoretically, let us say I brought in say 5 crores to build a hospital, but I needed 10 crores. So, 5 crores I brought from foreign funding donation, and I put 5 crores from the local Indian contributors, donors, I get it from them. Now, you can't cut that hospital and say 5 crores you take and 5 crores I will take. So, how will you be able to distinguish one from the other? It simply means if it is possible they will give you what can be given, and if it is not possible they will just not give you, that means they will take away your property. You just can't cut it like a cake and say okay, this part of the building you take and that part of the building I will take. This is absolute nonsense. So, it will never be effective and never be implemented. though in paper it may sound very rosy. Now there are penal provisions. New section 39 is being introduced, and that will bring in people who have long ceased to work for the establishment and may have quit or retired back. They will be brought for prosecution. And section 39 reads this: where any offence under this act or any rule or order made thereunder has been committed by a person other than an individual, every key functioning of such person who, mark these words now, at the time the offence was committed was in charge of and responsible to the person for the conduct of the business of the person, as well as the person, shall be deemed to be guilty of offence and shall be liable to be proceeded against and punished accordingly. Now what does this mean? These words mean at the time the offence was committed. That means it does not have to be today. Your offence may have been committed 10 years back, 5 years back. You may have left the company, you might have retired, you might have joined another company. Maybe you are also probably paralyzed, and maybe you are sick, maybe you are now aging and you can't work, and so you are gone. But this law will bring you back to stand in for prosecution and then for arrest, and all the harassment will start. So now you look, generally as per law, negligence per se is not an offence except in the case of death or injury to a person caused by a negligent act. You know section 304A IPC, especially we know about them as rash and accidents, death caused by rash and negligent act, death caused by rash and negligent driving. So you don't have an intention of killing someone, so it's not a murder. So it is a rash and negligent act. So 304A kicks in. That is now section 106 BNS Act. And under factories it is section 92 of the Factories Act 1948. Now look at these sections. It is simply not negligence which is an oversight which does no harm to any individual which is identified as an offence. In both these cases, whether what we call 304A and section 92, someone has to be injured, somebody has to die. That kind of negligence is what you are going to be prosecuted and punished if you are held guilty. But here, if you omitted to see something, because on a daily basis officials see so many things, they may not realize some slip done by a low official. So you will get booked, because you are in charge, you are the one who is running, and you suppose you approve it, you sign over it in good faith. How can you be then booked for it and then be hanged? First, to understand to whom FCRA Act 2010 applies, you must see subsection 2 of section 1 of the main act, FCRA Act 2010. It reads like this: it extends to the whole of India, and it shall, now the word is also, that means besides this other people are there, also apply to A, citizens of India outside India, and B, associate branches or subsidiaries outside India of companies or bodies corporate, registered or incorporated in India. Don't forget, as I mentioned earlier, by new section 39 in 2026 bill, even if you have resigned or retired or left the establishment and gone elsewhere for better employment, you can be brought back for prosecution. Now as far as who will be covered, first you will see citizens of India and citizens of India outside India. Secondly will be NGOs. Thirdly will be charitable organizations and institutions. Fourthly will be private charitable hospitals. Next will be private old age homes, homes for the poor and the destitute. Then we have religious organizations like church bodies and church institutions, even the schools run by the churches. All our minorities, including religious minorities, would be affected, and every other minority bodies. Missionaries who do good work like the Sisters of Charity of Mother Teresa and other missionaries which receive foreign aid. News channel, foreign and international, you understanding, when they register under Companies Act, they are required to register here when they are operating under the Companies Act. So even BBC is registered here in India. So all these people amongst others are not named here, but these are those who would get affected. So that what you will see would be affected. If your certificate is not renewed by refusal or just not renewed in time before the expiry by the central government, your registration will cease under section 14B and the property will vest first provisionally, of course they take it afterwards finally, with the designated authority. Now whether this is acquired out of foreign funds partly or fully, and even property not acquired out of these foreign funds. Second, provision for excluding the property from vesting is similar to Goa Escheats Forfeiture and Bona Vacancia Act 2024. This Goa bill first puts you out of the property and you have to fight back to get it back and get back inside your own property. Under FCRA Act, you will not be allowed rectifications. You will again, now all your assets will be frozen. So which means how will you fight a battle with your money from your own pocket? You will not have the means, you will not have the funds, you won't be able to engage lawyers, you won't be able to file appeals or whatever, make representations. You will have no money even to attend hearings. You are first frozen there. And then after that, your property is also attached, which means you will not be able to do anything with your property. And you will also end up landing in jail. Now don't forget, this amendment is also providing that action for prosecution can be initiated only after approval by the central government, which means the central government can pick and choose whom and where and when to prosecute or persecute and or to forgive or ignore. The clause 18 of this bill, they want to introduce section 43, and 43 is sought to be amended as this. In subsection 1, after that they want to insert subsection 2. No investigation shall be initiated for any offence punishable under this act except with the prior approval of the central government. So that is why this bill is clearly aimed at choking the opposition, choking dissent, shutting down NGOs which are critical of the government, shutting down social organizations which do not toe the line of the government, shutting down institutions, religious or otherwise, shutting down missions and missionaries, shutting down charitable hospitals, shutting down news channels and agencies who all do not follow the line of the central government. Such kind of laws are reminiscent of Hitler's era. This is nothing more than emergency by the back door, by changing the law but seeking to make it legal by first amending the law and then running riot to finish off any opposition. Hitler passed the Enabling Act, which allowed him to make laws to bypass parliament. He passed the Nuremberg laws, which stripped Jews of their citizenship and forbade marriage and sexual relations between Jews and non-Jews. He passed the Reich citizenship law, a law which defined who is a citizen and as a person who is a Jew or related blood, and Jews were classified as a separate race and they could not be full citizens of Germany. Instead, they were classified as subjects of the state without political rights. Remember the Citizenship Amendment Act which was brought in our country? Now Hitler changed the laws and the courts began upholding the action on the basis of amended law and putting people inside. Hitler did not tolerate dissent, and anyone who spoke against Hitler was arrested or beaten up by his SS gangs. BJP cannot tolerate dissent either. If you dare speak up against the government, you will be booked and arrested for sedition or booked and arrested for attempt to create hatred amongst communities. Do you remember the Nazi Germany slogan? If you are with Hitler, you are with Germany. If you are against Hitler, you are against Germany. This amendment you oppose in simply means if you are with Modi, all your crimes are overlooked and washed away, and which means you are with India. If you are not with Modi, you are against India and you will be jailed and your property will be confiscated. This is how BJP wants to finish off democracy in our nation. The government will claim it is seeking to flush out people who bring in money into our country for illegal purposes. but the existing law is enough to tackle that. This proposed amendment is clearly to stop opposing persons or persons critical of the government, choke minorities, stop foreign aid to charitable and missionary institutions and religious bodies and the religious communities, and finish them off. We need to oppose such draconic laws which are finishing off the citizens and the voices of dissent in democracy. It's time to rise up and express our voices so the government can listen to reason and follow democratic values enshrined in our constitution instead of trampling upon the rights and freedoms of the citizens. I repeat, this is clearly the Nazi regime of Hitler. The bill is unconstitutional qua minorities, as it will affect the rights guaranteed under the fundamental rights under Articles 29 and 30 of the Constitution of India. Whilst the government will claim and argue that this is not per se a deprivation of property or rights, but merely a regulatory mechanism to flush out illegal flow of foreign exchange into India or the illegal diversion of foreign exchange brought for one purpose to another, actually it will have the chilling effect of throttling the free flow of constitutional rights guaranteed to the minorities. Do you remember the Notbandi? The purpose claimed was actually supposed to be fantastic, flush out black money. Did they flush out any black money? How much black money was recovered? And how much official money itself? The circulated notes, how much of it came back? 100% did not come back. Do you remember the electoral bonds? A law made for official channel of corruption, complete loot, and the Supreme Court struck it down, and the BJP became very rich with the money, which I say was given under threats or to curry favors or payments of commission. I am actually very disappointed that the Supreme Court did not direct return of the money. Every political party which received the money should have returned it, including the BJP, anybody, I do not mind. But everyone should have returned the money, because this was not lawful, this was not correct, and this, if you want to get it subsequently, get it as a donation, no problem, but not through this electoral bond route. I want to ask the BJP, you declare the receipt of all incomes on the electoral bonds date-wise and with the amounts, and we will expose how this had become a quid pro quo for loot and an official route for corruption. If we remain silent, our nation will no longer be the great nation which our founding fathers dreamt of and for which our freedom fighters fought for our nation's independence. We are going back into time, into the bad Nazi period. Dictatorship is on the rise. Hitler is on the rise. Emergency is being imposed by an official route. God save our Mother India.